Can students wear what they want to express a political opinion at school? What if that opinion is unpopular or even controversial? Today, you might see students wearing shirts supporting a candidate or a cause, but it wasn't always clear if they had that right. Back in 1969, a landmark Supreme Court case, Tinker versus Des Moines, settled this question with a powerful statement about student rights. This case didn't just happen overnight. It was born from a time of deep national division and a desire for peace. Let's set the scene. The year is 1965. The Vietnam War is escalating, and the nation is torn apart. Every night, the news brought images of conflict and casualties into American living rooms. For many, especially young people, the war felt distant, yet deeply personal. Protests were erupting across the country, on college campuses, and in major cities. This atmosphere of dissent and debate trickled down from college students to high schoolers, who also felt compelled to make their voices heard. In Des Moines, Iowa, a group of high school and middle school students, including John and Mary Beth Tinker, decided they wanted to join the call for peace. Their plan was simple and silent. They would wear black armbands to school to mourn the dead on both sides of the conflict and to support a Christmas truce. It was a quiet, symbolic act of protest. They weren't planning to shout, to march through the halls, or to disrupt classes. They just wanted to wear a piece of black cloth on their arms. But school administrators in Des Moines got wind of their plan. Fearing that the armbands would cause disturbances, they preemptively created a new rule. Any student wearing an armband would be asked to remove it. If the student refused, they would be suspended until they agreed to come back to school without it. The school officials believed their primary job was to maintain order and a focused learning environment, and they saw these armbands as a potential threat to that order. As planned, on December 16, 1965, Mary Beth Tinker, who was only 13 years old, wore her black armband to her junior high school. She was promptly sent to the principal's office. As suspended, her brother John, who was 15, and their friend, Christopher Ricard, faced the same fate at their high schools in the following days. They were told they couldn't return to school until they removed the armbands. The students stood their ground. They believed they had a right to express their views, even if the school administration disagreed with them. Their parents supported them completely. With the help of the American Civil Liberties Union, or ACLU, the families decided to take a stand. They filed a lawsuit against the Des Moines Independent Community School District. Their central argument was that the school's ban on armbands violated the students' First Amendment right to freedom of speech. They weren't just fighting for their own children's right to return to school. They were fighting for a fundamental principle. The legal battle began. The core question was a profound one. Do students leave their constitutional rights, like freedom of speech, behind when they walk through the schoolhouse gates? The school district argued that they did. Their lawyers contended that schools are special environments where administrators need broad authority to prevent any potential disruption. They claimed the armbands could have led to fights, arguments, or general chaos, distracting from the educational mission of the school. They essentially argued for a no disruption, no distraction policy, where the potential for a problem was enough to justify censorship. The students, lawyers, on the other hand, argued that free speech is a cornerstone of American democracy and that it is a vital part of education itself. How can you teach students about the Constitution in a history class but then deny them their constitutional rights in the hallway? They argued that the school had no real evidence that the armbands would cause any disruption. In fact, no disruption had occurred. The students' protest was silent, passive, and respectful. The lawyers asserted that for a school to restrict speech, it must show that the speech would materially and substantially disrupt the educational environment. A mere fear, or an undifferentiated fear of disturbance, wasn't enough. The case worked its way through the lower courts. The initial district court sided with the school, agreeing that the ban was a reasonable way to prevent disruption. The case was then appealed to the U.S. Court of Appeals for the Eighth Circuit, which was deadlocked, meaning the lower court's decision stood. The Tinker family and the ACLU knew this was too important to give up on. They decided to take their fight all the way to the highest court in the land, the United States Supreme Court. In 1968, the Supreme Court agreed to hear the case. The arguments presented before the 9 justices mirrored the ones from the lower courts. The school district's lawyers emphasized the need for discipline and order in schools. They painted a picture where administrators are constantly on guard, trying to prevent conflicts before they start. The students' lawyers, however, championed the idea that schools should be marketplaces of ideas, where students learn to engage with different viewpoints respectfully. They argued that suppressing silent political expression teaches students a dangerous lesson, that their voices do matter, and that authority should not be questioned. Finally, on February 24, 1969, the Supreme Court delivered its momentous 7-2 decision. The court sided with the students. In the majority opinion, written by Justice Abe Fortas, came one of the most famous and powerful sentences in the history of constitutional law. He wrote, "It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate." This single sentence became a rallying cry for student rights for decades to come. The court's reasoning was clear. They found no evidence that the armbands had caused any disruption or interfered with the educational work of the school. The school's ban was based on a fear of what might happen, not on what actually did happen. Justice Fortas pointed out the hypocrisy of the school's policy. He noted that the school allowed students to wear other symbols, like political campaign buttons, and even the Iron Cross, a symbol of Nazis. The school had singled out one specific viewpoint opposition to the Vietnam War for suppression. This, the court said, was unconstitutional. The ruling established what is now known as the Tinker test. This legal standard says that student speech is constitutionally protected unless school officials can prove that the speech would materially and substantially disrupt the work and discipline of the school. This decision didn't give students unlimited free speech rights. For example, speech that is obscene, libelous, or that directly incites violence is not protected. But it did create a high bar for schools to meet before they could censor student expression, especially political expression. The impact of Tinker versus Des Moines was immediate and profound. It armed students with the legal backing to express their views on important social and political issues. It affirmed that public schools have a responsibility not just to teach academics, but also to nurture the principles of democracy, and that includes respecting fundamental rights. The case has been cited in thousands of legal disputes since, shaping policies on everything from student newspapers to dress codes to off-campus online speech. Of course, the debate didn't end in 1969. Since the Tinker decision, the Supreme Court has revisited the issue of student speech several times. In cases like Bethel School District versus Fraser in 1986, the court ruled that schools can prohibit lewd and vulgar speech. In Hazelwood School District versus Kumeyer in 1988, it gave schools more authority to regulate school-sponsored speech, like articles in a student newspaper. These later decisions have narrowed the scope of the Tinker ruling a bit, creating a complex legal landscape. But the core principle of Tinker remains unshaken. Students are not just empty vessels to be filled with information. They are citizens in a democracy, with rights and opinions that deserve protection. The story of Mary Beth and John Tinker is a powerful reminder that even young people can make a huge difference. Their quiet act of wearing an armband led to a legal battle that strengthened the fabric of American freedom. It showed that justice can prevail when people are willing to stand up for their rights, even against powerful institutions. The legacy of Tinker v. Des Moines is a testament to the idea that freedom of speech is not just for adults, politicians, or journalists. It belongs to everyone, including the students sitting in classrooms across the country. It's a vital part of their education and their journey to becoming engaged, active citizens. Thank you for joining me on this deep dive into one of the most important legal cases for student rights. If you found this story inspiring and want to learn more about the landmark decisions that have shaped our freedoms, be sure to follow my channel. We'll continue to explore the stories where justice defended freedom and democracy. Thanks for watching, and I'll see you in the next video.